paragraph 85 of Itula. And what I'm going to suggest is that our submission and our interpretation of the court's judgment is given effect to in paragraphs 42 and 43 of Electoral Commission versus Swapo on 207. Let me just make a flag. When the President tells the court in his affidavit, he was told that there was an unknown number of registered voters who were disenfranchised or possibly couldn't vote. He says he had two options. He's wrong. He had a third option, what the Electoral Commission did in Swapo. They approached the court. And they said, you know what, well, I don't need to read it. The court knows what the Electoral Commission did. There was a mess. The Electoral Commission came to court and said, we need the court's help, Electoral Court, and they set aside those particular elections. President, the Commission in this case had the exact same option, but they ignored it. They don't even contemplate it in their affidavits. So that's the flag that I put out there. But let me turn to 207 and the discussion of this 115 provision.
Proposing is the self-review option. Why does your self-review necessarily relate to setting aside the entire election? Why would self-review not involve, for example, the court granting an order to extend the voting?
Well, it's
you have committed yourself to a particular option, and I want to investigate that with you. Why necessarily set aside the election?
Yeah, my Lord, I've given you a third option. Your Lordship has given me a fourth one. There may even be others. I'm not commenting on that. All I'm saying is the President took the view.
Is from your client's perspective, why that was not an option?
What? I'm not suggesting it's not.
Sorry?
I'm not suggesting it wasn't an option.
I see.
I'm not suggesting
it just escaped your mind.
No. There might be other options. I'm not commenting on. What I'm saying is the President came to court and he said to this court, I had two options. All I'm suggesting is there were other options. I pointed out one, and your Lordship has pointed out another self-review option. Or not a my option was self-review, your Lordship's option was another one. Possible. And that other option I haven't applied my mind to it, but it might well have been available to the President. I haven't applied my mind to whether it was or it wasn't, but on first principles, I think it might well have been available to the President. He had a mess. He had to fix the mess. What does he do? He can't take the law into his own hand and make up Section 64(1)(b) powers which don't exist. So I turn to paragraph 42 on 207. Immediately above paragraph 42, one sees the quoting of...
Interrupt. But you may wish to wrap it up because we're about here.
So I'm going to wrap up by just referring to the paragraphs that are stated. 42, immediately above 40, this is on page 207 on our bundle. Immediately above paragraph 42 is the reference to 115, and it's quoted in full with some of it in italics. In the Itula matter, paragraph 85, which I've been talking about for the last 5 minutes, it deals with what this court says and it quotes it. Then in 43, it interprets what it says this court said in 85. And it says, our reading of 115 is that the jurisdictional facts that must be present for a court to uphold an election, that means if those jurisdictional facts are not there, then it must set it aside, or that the court must be satisfied the election in question was conducted in accordance with the principles laid down in the Act, and the mistakes or non-compliance with the Act do not affect the result. In our view, if both those jurisdictional facts are not met, then the court will exercise discretion and invalidate the election. That's it. So either this court must invalidate, or, as the electoral court put it, it will exercise the discretion and invalidate, as it pleases the court.
Thank you, Mr. Katz.
I haven't.
Perhaps,
if one wants guidance, this court may take guidance from the electoral court's orders, which you will find on page 213, 214, where the electoral court upheld the self-review by the Commission and made certain orders. I know that there obviously are differences by virtue of the nature of case by case.